ஹாய் வியூவர்ஸ், இது உங்கள் மாற்றி யோசிப்போம் மாற்றங்களை வசமாக்குவோம். நான் உங்கள் வித்யாலக்ஷ்மி. இந்த வாரம் நம்ம கூட அட்வொகேட் மிஸ்ஸஸ் கவிதா, மெட்ராஸ் ஹைகோர்ட், லா ஆஃப் அபார்ஷன் இன் இந்தியாவில் கருக்கலைப்பு சட்டம் எப்படி அப்படிங்கிற விஷயத்தை ஷேர் பண்ணியிருக்காங்க. வி வெல்கம் மிஸ்ஸஸ் கவிதா டு ஷேர் திஸ். தேங்க்யூ.
Hello viewers. Last week I had spoken to you about the laws relating to the protection of women and children in India, and I'm glad to know that a lot of you have found it very useful and informative. But there is one subject on which I had not touched upon in my earlier talk, and that is the law relating to the medical termination of pregnancy in India, the law of abortion. A lot of you have asked me some specific queries. You wanted to know what is the exact position now that there is a lot of talk about the amendment to the earlier 1971 Act. The MTP Act of 1971 is being amended. The Lok Sabha has passed the amendment bill, and the bill has not yet been tabled in Rajya Sabha only because of the lockdown. So I'm sure that we're going to have a new act very soon. The law relating to abortion in India is governed by the Medical Termination of Pregnancy Act 1971. This act is a relatively small act, a small enactment which only talks about the grounds on which a medical termination is made permissible under the law, and it also talks about the length of the pregnancy within which a medical termination of pregnancy is made permissible. So it says that if the length of the pregnancy has not exceeded 12 weeks, then the approval and permission of one registered medical practitioner, one doctor, is required. If the pregnancy has exceeded 12 weeks but has not exceeded 20 weeks, then the approval and permission of two registered medical practitioners is required before an abortion can be done. Now, what are the grounds on which an abortion is permissible? There are only two grounds which are mentioned in the enactment. Number one is risk to the physical or mental well-being of the woman, that is the mother. And the second one is risk of any deformity or abnormality in the fetus or the child to be born. These are the only two grounds upon which registered medical practitioners decide on whether an abortion can be made permissible in a particular case. Now, the Act further clarifies what is risk to mental well-being of a woman. So it brings within its fold unintended or accidental pregnancies. Accidental pregnancies are those which are caused by a contraceptive failure, which are not intended pregnancies. In such cases also, the law permits abortions as it brings it within the fold of risk to the mental well-being of a woman. But here, the important thing to be noted is that the 1971 Act only talks about unintended pregnancies of married women. Therefore, unmarried women or unmarried couples cannot get the benefit of this clarification unless the risk to the mother or risk to the child, which are the only two grounds mentioned in the enactment, are proved, and which are specifically approved by the registered medical practitioner. So in this regard, the Amendment Act is actually a final light at the end of the tunnel. See, law is not static. It is as vibrant as society itself. And with changing times, see, when we are able to include live-in relationships within the fold of domestic relationships for the purpose of the protection of women against the Domestic Violence Act, then in that case, unmarried couples should also be given the benefit of the right to abortion in respect of unintended pregnancies. And this has finally been noticed by the Parliament. And this lacuna in the earlier enactment is now being remedied. And the law has now been amended to mean that even an unmarried couple who wants to abort the fetus in case of an unintended pregnancy can also undergo an abortion, and the law permits this. So there is no need for any further secret abortions or any further unsafe abortions. In this context, I must inform you that about 10 to 13 women die every day in India because of unsafe abortions. Who are these women? They are the unmarried women who did not have the benefit of a legal abortion, and therefore the Act is a light at the end of the tunnel finally for such kind of women. because they are putting themselves, their lives, their health to danger. And this act of 2020 finally remedies that aspect, and it gives the benefit of abortion to unintended pregnancies of unmarried women as well. Also, the length of pregnancy has been increased. The 12-week period has now been increased to 20 weeks. So, if the length of pregnancy has not exceeded 20 weeks, then only one registered medical practitioner's approval is required. And in respect of pregnancies between 20 to 24 weeks also, the Parliament has stated that the state government will make detailed rules about in what cases these kind of pregnancies can be terminated medically. But these generally relate to special categories of cases where the pregnancy has resulted from a rape or out of a sexual violence or out of an incestuous relationship. In fact, the amendment bill goes further and says that no upper limit for the length of pregnancy is required in cases where there is a substantial proof of an abnormality in a child, in the fetus. And for this, the law requires the constitution of a medical board which will decide, which will weigh the advantages and disadvantages, the pros and cons of an abortion, and they will decide and they will approve an abortion in case they find that the abnormalities or the deformities of the child are very well proved even after 20 weeks. So, if I can summarize, the Medical Termination of Pregnancy Act 1971 as amended by the Bill of 2020 is now a very progressive piece of legislation because it gives the benefit of abortion in respect of unintended pregnancies to also unmarried women and unmarried couples, and also it increases the length of pregnancies within which an abortion is made possible by law, taking into consideration the advancement of science, taking into consideration the various other aspects, and also the various petitions filed before the Supreme Court and the High Court in cases where parents came to know about the deformities in their fetus much after 20 weeks. In such a case, it is a very, very emotional decision for the parents, but if a registered medical practitioner finds that in the best interest of the mother and the child, it is necessary to terminate the pregnancy, then it has been made possible today by the law. There is one more aspect that the amendment bill talks about, and that is about the right to privacy of the woman who decides to undergo abortions. Now that the amendment bill has spoken about the right of unmarried women to abort their fetuses in respect of an unintended pregnancy, it is also important to talk about the protection of her identity. That is, not to divulge her identity to the general public. So that has been made a specific provision under the amendment bill, and it is also made a punishable offence if a registered medical practitioner discloses the identity of her patient who wishes to undergo abortion, especially in case of an unmarried woman. So this is all about the law of abortion in India as it exists today, and we are also awaiting the amendments by way of the amendment bill of 2020, which is soon to become a law. Thank you.